Good morning everyone, and welcome to another in our series of lectures, and this module covers legal issues and documentation of patient reports. So what are the learning objectives for this week, or the learning outcomes? So after completing this module and engaging in the readings, tutorial activities and listening to the mini lectures, you should be able to have an understanding of the legal principles governing documentation of patient care, have an understanding of how healthcare records can be used from a legal perspective, and understand the guidelines and principles governing nursing practice, and which directly relate to quality documentation practices. So let's begin by just giving an introduction to report writing or documentation per se. The writing of patient reports is a vital part of a nurse's work. It's integral to what we do. Think of all the places that you actually document. For example, you'll document in progress notes, on observation charts, might be consent forms, fluid balance, nursing care plans, discharge summaries, community referrals, medication charts, IMS reports or incident reports. So it's broad ranging. The patient's records, particularly the written reports by health personnel that are incorporated into the record, what do they actually do? Well, they constitute an ongoing account of the patient's experience whilst they're at hospital. So it's like a transaction. You enter hospital, from the moment you enter and you're admitted to the moment that you're discharged, your healthcare record is a picture of your whole experience. The written reports provide an assessment of progress for health professionals, and it's also an indication of patients' transition to perhaps their next stage of treatment. They also provide a record of treatment given, progress made, and they are a documented history for future consultation or admissions if required. Some other additional things that healthcare records can be used for, they can be used for teaching purposes. For example, think of yourself as a student and the number of times that you might be looking at healthcare records purely for teaching and learning purposes. And also they're used in audit and in quality and research purposes. So there's no doubt healthcare records are particularly important. Now, you will be learning about, obviously, good documentation practices throughout your 3 years. It's a developmental skill, and, particularly in your clinical subjects, you practice that whilst in labs and on workplace learning. But from this subject perspective, it's important to know that from time to time, a patient's healthcare records will be required as evidence in court, or they'll be used in evidence. And it's important to stress, though, that it's not the most important reason for writing good healthcare records. Obviously, it's, just something that you must attain a very high standard. But nonetheless, from a legal perspective, should a situation arise where, for example, the relevant health authority or, an individual medical practitioner or nurse might be served with a subpoena, and that requires them to produce relevant records. So if it's a criminal proceeding or civil proceeding, they'll need to be used in evidence, and there's a whole process. And that's what I'm going to talk about now. Patients' records can be used in civil and criminal proceedings and in coronial hearings. So let's just look at some of the reasons why that might occur. So patient records, when used as evidence, Now, obviously throughout the subject you've been learning about the difference between the civil jurisdiction and the criminal jurisdiction. So, in civil proceedings against healthcare organisations or hospitals, a patient's healthcare record is often used as evidence to support, for example, an allegation that a certain treatment was wrongly given, or that there was an actual failure to give a particular treatment. Patients' records can also be used as supporting evidence of other matters that might be in dispute in the civil jurisdiction. For example, that a particular injury occurred as a result of an accident, and or the circumstance in which it was alleged by the patient to have occurred. So that's one way for in the civil jurisdiction. And then we have when, a patient's healthcare record is used when a crime might have been committed. For example, a patient's healthcare record can be used as evidence that an assault or an injury actually happened, and to show the nature and extent of that injury. For example, in relation to a charge of sexual assault, it may be that the first place the victim presented for help was the emergency department of a hospital, and on arrival the victim would invariably give an account of events leading up to his or her presence at the hospital. That would be documented, and then subsequently in the criminal proceeding, that healthcare record will be vital evidence in that case. So in such a situation, the health professional's record of the words used in relation to the complaint made and the injuries sustained may become important evidence in the criminal charge that may well follow. So, recognising the legal ramifications of documenting appropriately, factually, and so on. Also from the legal perspective, and we look at this in a little bit more depth in the next module, is in coronial hearings. Now, in coronial hearings, the purpose of the investigation is to determine the nature and cause of death. Alright, so the coroner's job is when a patient or anyone who died unexpectedly, and obviously within a hospital environment, if a patient were to die as a result of negligence or failure to do something, whatever that may be, the coroner's job is to put together the pieces in the puzzle to determine what happened when that patient came into hospital, their pathway through the hospital, and subsequently, the cause of surrounding their untimely death. So it goes without saying that one of the most important things, as well as verbal evidence by nurses and doctors and everyone else, but it's the documents that are written, the healthcare records during their time in hospital, that will be closely and carefully scrutinised. So, healthcare records, if they're written well, they can track a person's deterioration to identify whether any errors or adverse events occurred during the patient's stay, and so on. For whatever purpose a patient's records may be required in legal proceedings, such records, and that includes the nursing records, will be subject to, and I can't stress this, close and careful scrutiny that will be absolutely picked apart. It is really important, therefore, that these records meet the standard expected of them, and having regard to the purpose for which patient records are used. So always in the back of your mind thinking every healthcare record that you are, the scribe of, the author of, should meet that standard every single time, because it could be that one time that the healthcare records of a particular patient you're looking after may well be subpoenaed. You're asked to present a statement and or appear as a witness in a coronial inquiry. If records are an accurate and factual account of good patient care, then they provide valuable assistance in a court of law.